के काउंसिल है
वो कनेक्ट करेंगे जी
जो हम दिखाने जा रहे हैं वो ना आपने बहस किया ना उन्होंने बहस की, इसी लोगों को आपका जो गाड़ी विलेज है ना उसका तो लैंड एक्विजिशन ऑफिसर ने अपना फिक्स्ड अमाउंट फिक्स किया, बाकी कैलकुलेशन से तो नहीं पता चल रहा है कि कौन सा जमीन अलग अलग रेट है सबका, राइट, पता नहीं चला। लेकिन गाड़ी के कैलकुलेशन से लग रहा है कि जो यूनियन ऑफ इंडिया ने आपको ऑफर किया वो ऑफर ही 80% था, ऑफर ही 100% नहीं किया। एंड फॉर दैट 2 documents is required to be seen. पहले तो ये इनका अवार्ड जो है गाड़ी वाला, गाड़ी इसलिए लिया क्योंकि फ्लैट रेट है, इजी है उसको समझना। ये दिखाई दे सीरियल नंबर 98 देखिए, दिस इज अवार्ड नंबर 98 हजाम, राइट, ओके। अवार्ड देखिए, सप्लीमेंट्री अवार्ड, सप्लीमेंट्री अवार्ड देखिए, उसका पेज नंबर 246 यानी कि 18, सप्लीमेंट्री अवार्ड का पेज नंबर 18, इसमें अवार्ड नंबर 98 विद रिस्पेक्ट टू विलेज गार्ड। अवार्ड भी नहीं है, रिकॉर्ड भी नहीं लेके आए अपने, मतलब व्हाट काइंड ऑफ, फिर क्यों नहीं लिखा रहे हम कोर्ट में?
सारा रिकॉर्ड तो लाए लेकिन
एक कोई भी ना वो जो क्लेमेंट का रिकॉर्ड है उनको दीजिए, आप भी देखिए इस चीज को, बिकॉज द फाइंडिंग इज गोइंग टू बी रिकॉर्डेड ऑन दिस बेसिस। मिला? सीरियल नंबर 98 में एमेंडेड अवार्ड में सीरियल नंबर 98, अपेंडिक्स 2 मिला? हजाम नाइन्टी एट में है। नाइन्टी एट में ना सप्लीमेंट्री अवार्ड में 98 अवार्ड में सीरियल 98 देख लीजिए,
4.93 acres
4.57 acres 98 मिला? नहीं ये रामेश्वर ठाकुर हजाम,
हाँ नॉट 76 सीरियल
76 सीरियल,
पेज नंबर 18,
पेज नंबर 18, सीरियल नंबर 98,
4.57 एकर्स
4.57 एकर्स
41,750,
ठीक है।
and they have been paid 23,000 only 21,500.
दिस इज मैचिंग विद द एग्जिबिट जो मैंने अभी आपको बढ़ाया है एग्जिबिट। आप देखिए ना 21,512 मैच कर रहा है ना पेमेंट, हर चीज आपके खिलाफ नहीं बोलते हैं हम,
नहीं
थोड़ा समझिए क्या बोल रहे हैं। अवार्ड नंबर 98 के अगेंस्ट में 21512 का पेमेंट दिख रहा है कि नहीं दिख रहा है?
हाँ 21512 का
दिख रहा है, उनको भी दिखाइए, उनको दिखाइए, उनको दिखने का ज्यादा जरूरत है, सुबह से यही देख रहे हैं हम। दिखा? अवार्ड के साथ टैली कर रहा है, राइट? अवार्ड नंबर 98 दिख रहा है, 76 सीरियल नंबर है, अवार्ड नंबर 98,
हाँ ठीक है,
दिखा?
98 minus 4.57 acres,
ठीक है, करेक्ट। अब ये गाड़ी का है, गाड़ी का फ्लैट रेट फिक्स हुआ था, राइट? गाड़ी का फ्लैट रेट था 5882, ठीक है? अगर 4.57 एकर्स एक्वायर हुआ है तो इसको 5882 से मल्टीप्लाई करने से आपका कॉम्पनसेशन अमाउंट लैंड का आना चाहिए ना, आ रहा है 26,880। कैलकुलेट करके देखो, दीजिए भाई उनको कैलकुलेटर। 4.57 इंटू 5882, आया 26,880.74।
ये 26,880 है।
ठीक है, आपने दिया कितना है? 21,512। अगर उसका 80% निकालेंगे ना तो लगभग इतना ही फिगर आता है। उसका करिए 80%,
50%
आ रहा है 21,504.59।
21,504 रुपीज एंड
ठीक है, तो इन आपने तो पूरा ऑफर ही नहीं किया अमाउंट, आपका ऑफर ही नहीं है 26,880 का। आपने ऑफर किया है 80% और पेमेंट भी किया है 80%। आपके एग्जिबिट में ना एरिया नहीं लिखा हुआ है और इसमें एरिया लिखा हुआ है, इसीलिए आप लोग का सबमिशन में एरर है कि पूरा अमाउंट जितना था 100% हमने ऑफर किया और पेमेंट हो गई। दिस इज एब्सोल्युटली इनकरेक्ट। एक सैंपल ले लिया करेक्ट कैलकुलेशन के लिए और आप सेटिस्फाइड हो जाइए इस कैलकुलेशन से, देन आई विल गिव माय डिक्टेशन ऑन दिस। राइट, ये तो 2 + 2 4 वाला बात है, जितना बार मल्टीप्लाई करेंगे चेंज नहीं होने वाला। ये दिखा दीजिए भाई, गाड़ी का ये उनको भी दिखाइए एसडी साहब। हाँ ये दिखाइए, ये देखिए इतना ही ऑफर हुआ, इतना पेमेंट हुआ, बात खत्म हो गई। आपने 100% उनको ऑफर ही कहाँ किया? Yes, calculation.
Others are also figures is matching.
हम यहाँ पे मेरा आपका क्या आर्गुमेंट है क्या कि इसमें कोई भी फिगर गलत है? हम तो मैच किए क्योंकि हमको 80% टैली करना था। That is not your case and that is not your argument. Improve करने का कोई स्कोप नहीं है. This is something which I am confronting you because this point was never argued by anyone.
We rely on the award because this.
That's right.
We did not travel to this.
तो जाना पड़ता है ना हम लोग को जज बनने।
That is because day one I said that we are running short of this document. I said day one.
नहीं हम आपको दिखा रहे हैं ना?
Yes.
दिखा रहे हैं, आपने इसको पेश किया था।
इसको वो दूसरे वाले।
एक ही बात है ना, You see, बाकी सब में नहीं बोल सकते हैं क्योंकि उसमें क्लासिफिकेशन ऑफ लैंड है, किसका एग्रीकल्चरल है, किसका धान 1 है, धान 2 है, वी आर नॉट एबल टू फिगर आउट, ठीक है. लेकिन दिस इज वन वेयर देयर इज अ फ्लैट रेट फिक्स्ड फॉर गाड़ी एंड देयरफॉर आई हैव पिक्ड अप गाड़ी, and in the uniform manner you have paid everybody. So your contention that whatever amount each of the claimant had come, he had taken 100% of his claim and only 80% of the claimant had come to take the payment is not correct.
Amount payable that is indicated there.
Payable मतलब क्या? Payable 21,000 आप कैलकुलेट करके देख लीजिए.
नहीं वो तो ठीक है, मतलब हमने जो बेसिस पे बोला,
हम आपके सबमिशन की बात नहीं कर रहे हैं.
That is correct.
हम रिकॉर्ड की बात कर रहे हैं.
Yes, when it is part of record, I cannot exceed my brief.
That's it. I will record your submission, but I will give my finding on this.
Yes.
आपका
But my
submission.
intent was never to give a wrong
भाई
flag.
आपके इंटेंशन की कोई बात नहीं.
And I cannot exceed the record.
You see, when I see the record,
Yes, sir.
I see it very carefully. That is why I take my own time.
Yes, I understand.
Right?
I understand.
रिकॉर्ड पढ़ने में हमसे एरर कमी होता है, लेकिन चूंकि ये एक ऐसी चीज थी जो उन्होंने भी पॉइंट आउट नहीं किया.
I go down.
When I was calculating it, I found that what was offered was only 80% and not 100%. And ultimately there was no agreement.
So that's
Like did
arbitrator has been calculated.
कागज मेरा वापस करिए. आपका रिकॉर्ड है और वहाँ कुछ और तो नहीं है आपके पास.
मेरे पास तो बस इतना ही.
बस ठीक.
आपका रिकॉर्ड लेके
नहीं कभी छूट जाए वहाँ पर. अभी मैंने दिया था देखने के लिए.
Yes, yes, I go down. I stand corrected because I cannot exceed the record.
आपकी तरफ से कुछ है ही नहीं. रिकॉर्ड पढ़ रहे थे, कुछ स्ट्राइक किया, सोचा कुछ कैलकुलेट करके देखते.
नहीं ट्रू.
तो अवार्ड के साथ जब मिलान करने लग गए तो बाकी सब में it was not possible to calculate because the nature of the land is not
classified.
गाड़ी was the only award जिसमें फ्लैट रेट में है. तो सिंपल मल्टीप्लिकेशन करके देखा और उसके बाद देखिए कि अप्रोक्सीमेटली 80% ही ऑफर हुआ. So therefore the argument of the claimant that only 80% has been given to them is absolutely correct. And this particular document reveals that only 80% was offered to them. It is not a case कि आपने पूरा ऑफर किया और पूरा उसमें से 80% उनको दिया गया. ऐसा तो आपका डॉक्यूमेंट ही नहीं बताया. So therefore agreement, deemed acceptance, ये सब का बात कहाँ है? एविडेंस में वो बोले हैं कि हमको नहीं पता है कि किस रेट से हमको मिला. हमको मिला, हम दिए जितना दिया हम लोग. जो भी
हम that is my case.
एविडेंस में बोला है विद प्रोटेस्ट लिए हैं. कोई क्रॉस एग्जामिनेशन नहीं. कोई क्रॉस एग्जामिनेशन नहीं.
80% if I just one line. Now this is where I concluded 80% of the amount that was determined. So I presume that 80% he did. Yeah, the record is saying so. So that 80% was received of the principal amount. Without protest, that will be my submission.
Offer is not complete. नहीं अभी क्या आपका सबमिशन, आपका सारा सबमिशन रिकॉर्डेड है. लाइक
तो आपके पास है.
ठीक है.
I go down. Usually will be there.
हाँ ठीक. That is why I call you.
Yeah.
आगे तो नगर 18 submissions. The learned ASGI during the course of arguments has specifically submitted that by referring to exhibit R2A by 3, R2B by 3, R2C by 3 and R2C by 4. that most of the claimants had put their signature and had taken the amount offered to them without registering any protest. And I submitted that there were others who did not come forward to accept any amount. And therefore, 80% of the claimants had taken 100% of their claim, of the amount offered by the Union of India. 80% of the claimant had accepted 100% of the amount offered by Union of India. Okay? On the other hand, it is the specific case of the claimants that whosoever claimant was paid, they were paid only 80% of the amount. In that connection, regarding acceptance of amount without protest, the Learned Counsel for the Union of India has referred to the judgment passed by the Honorable Supreme Court reported in 1995 supplementary within bracket 4 bracket close SCC 600 Union of India versus Munsha and others, and also the judgment passed by Honorable Supreme Court in the case reported in bracket 1996 bracket close 7 SCC 740 Union of India versus Satyavati. In order to examine as to what amount was offered to the claimants and whether the amount paid to them was under protest or not, this court finds that the award in connection with the 4 villages except Gari was based on classification of land. And therefore, and since no such material has been brought to the notice of this court as to the nature of land with respect to one or the other claimant, and even the exhibit R2/A/3, R2/B/3, R2/C/3, and R2/C/4 also do not reflect the nature of the land with respect to one or the other claimant. This court, and it is also not very, this court found it proper to examine a sample case in connection with the village Gari, wherein there was no classification of land for awarding compensation by the authorities, and the compensation was fixed by the authorities at the rate of rupees 5882 per acre. From the perusal of exhibit R2/B/3, just by way of sample relating to award number 98. The same has been prepared in the name of Ram Naresh Hajjam and Lal Mohan Hajjam and Narayan Hajjam and Tulsi Hajjam and Dhanu Hajjam, son of Jagu Hajjam of village Gari. And the offered amount which has been paid is shown as rupees 21,512. However, the area of the land acquired for this award has not been mentioned in the aforesaid exhibit. From the perusal of the award, in relation to village Gari, the award number 98 finds place at serial number 76, wherein the paid amount has been shown to be rupees 21,512 and the land acquired in connection with this award has been shown as rupees 4.57 acres. No argument has been advanced by the learned counsel for the parties questioning any of the facts and figures which have been mentioned by the learned arbitrators in the award. Otherwise also, with respect to award number 98, which has been taken by way of sample, the figures are matching. And admittedly, it relates to village Gari. In such circumstances, if 4.57 acres is multiplied by 5882 per decimal, which is the rate fixed for village Gari, the amount comes to rupees 26,880.74. And what has been paid as shown in the award, in the improved award as well as exhibit R2/B/3 is 21,512, which comes to approximately 80%. And the 80% constitutes 80% of 26,880.74 is equivalent to 21,504.59. In view of the exhibit R2/B/3, it appears that under the heading award payable to each, the amount of rupees 21,512.00 has been shown against award number 98, meaning thereby what has been offered to the claimant was 21,512 only with respect to award number 98 and not 26,880.74. And consequently, the offered amount was approximately 80%. In view of the aforesaid facts which is apparent or by way of sample calculation as shown above, this court and the council, the learned ASGI, has been confronted with this aspect of the matter and he could not dispute the calculation as stated above. In such circumstances, the argument of the learned ASGI that 80% of the claimant were offered 100% of the amount and they had taken 100% of the amount without any protest. They had accepted 100% of the amount does not appear to be correct. It appears that out of the awarded amount, only 80% was shown to be the amount payable to the claimant as per Exhibit R2B/3, which was accepted by the claimant by putting his signature, although no protest as such has been written while accepting the
मेरा
award.
सिग्नेचर नहीं, वो अलग से बनता है जो पेमेंट होता है।
आपका वो नहीं जानते अभी, आप यहाँ पे किसका
इसमें
सिग्नेचर?
डीएलओ का सिग्नेचर है, मेरा नहीं है।
ओ,
उसका वाउचर अलग बनता है, उन लोग पेपर वो लाया नहीं है एविडेंस। उसमें रेवेन्यू टिकट रहता है, मुखिया का सिग्नेचर रहता है, विटनेस के बिहाफ में दिया जाता है उसको। सारे डीएलओ का
but no protest has been mentioned therein. At this stage, the learned counsel for the claimant has submitted that all the signatures which has been mentioned against each of the award in Exhibit R2B/3 appears to be of one and the same person. सबका एक ही जैसा award appears to be of one and the same person, which is a signature of the district land acquisition officer, and it is not the signature of the claimant, of the concerned claimants. He has submitted that. बस इतना ही बहुत है.
वो वाउचर लोग वो डॉक्यूमेंट लाया भी नहीं।
He has also submitted that the voucher by which the payment was made to the claimant has not been exhibited by the Union of India before the learned arbitrator. The aforesaid aspect of the matter has to be seen with the aforesaid aspect of the matter has to be seen with the oral evidence adduced by the parties. The oral evidence by the parties. The claimants had examined 4 witnesses and it is not in dispute that similar statements has been made on behalf of by all the 4 witnesses, and the questions put to them is also of similar nature. एक ही है cross examination, by way of cross examination is also of similar nature. The witness number 1 for the claimant has stated in paragraph 3 that they had accepted the amount of compensation under protest, and they had also filed application for enhancement of compensation. But admittedly, the application for compensation has not been exhibited. However, at the same time, there is no cross-examination of this witness by the Union of India. इस पर कोई क्रॉस एग्जामिनेशन नहीं. इस पॉइंट पर कोई नहीं. Similarly, the witness number 2 has also made identical statement, but there is no cross-examination on this. It is important to note that while cross-examining witness number 1, in answer to question number 15, he stated that he could not say at what rate the payment was made to him. So far as witness number 2 is concerned, there is also no cross-examination with respect to payment received under protest. In response to question number 6, the witness number 2 has stated that question number 6, which was whether you endorsed your protest while receiving amount of compensation. The witness has said that, oh, yes, I had put my signature over payment slip after putting my objection/protest. But admittedly, the payment slip/protest has not been exhibited by the Union of India, as the same would have been in the custody of Union of India. With respect to question number 5, this witness has stated that he did not remember the rate of compensation. So far as witness number 3 is concerned, he has also stated that he had accepted the compensation under protest and had given application for enhancement of compensation, but this witness has not exhibited the application for compensation, enhancement of compensation. This witness has also been cross-examined. And in paragraph 12 of his cross-examination, a question was put by question number 12, whether the villagers accepted the compensation amount without any protest, to which he answered, inverted comma, no, it is false. The villagers had made their protest while receiving amount of compensation. The witness number 3 upon cross-examination by respondent number 2 before the learned arbitrator has stated that in response to question number 9 has stated that he had received the amount of compensation with objection. The witness number 4 has also made similar statement that he had received the objection and request and had filed application for enhancement of compensation. This witness has also been cross-examined by both the respondents before the learned arbitrator, and with respect to question number 8, whether you have accepted the amount of compensation of land without any protest, he answered, inverted comma, no, I had accepted the amount of compensation with protest. With respect to question number 9, inverted comma, whether before signing the payment voucher you recorded your protest, he answered, inverted comma, yes, I had recorded my protest at the time of receiving payment of compensation and I had put my signature over payment voucher. I signed on the payment voucher by endorsing objections/protest to the same payment. During the cross-examination by respondent number 2, with respect to इसको छोड़ दीजिए, इसका कोई है नहीं, nothing important. All the witnesses during their cross-examination have also stated that they are not being paid the compensation amount as per the market value of the land. This court finds that on the one hand, what was offered to the claimants who had received payment was not the full amount of compensation but tentative 80% of the compensation as assessed by the concerned authorities. And they had also stated during their evidence that they had accepted the payment with protest, and during their cross-examination they have stated that they had registered their protest on the payment voucher which was executed by them. The payment voucher has admittedly not been exhibited before the learned arbitrator by the Union of India. There can be no dispute that payment voucher would have been in the custody of Union and not in the custody of the claimants. In view of the aforesaid facts and circumstances, this court is of the view that the Union of India never offered the entire amount of compensation to the claimant. And thereafter they slept over the matter. This court is also of the view that though only a part amount of compensation to the extent of 80% was offered to them, but the witnesses of the claimant have consistently deposed that they had accepted the payment under protest by registering their protest in the payment order. So far as the evidence of the respondents is concerned, of the respondents before the learned arbitrator is concerned, two witnesses, three witnesses were examined. The witness number 1 on behalf of the respondent
Paragraph on SDO 2 of Defense State Officer Job Circle Danapur Act.
Yes. He was working as SDO Roman 2 in the Office of Defense State Officer, Job Circle, Danapur, Kant, since July 2013. And in paragraph 5, he stated that the land users had accepted the amount of the award without any protest in the year 1970 itself. And therefore they cannot claim more amount after a long time. And has stated that most of the claimants never made any objection. And in para 8, he has stated that sufficient compensation has been given to the claimant as per the existing market value, and now they are not entitled to get any more compensation. He has relied upon the relevant records produced before the learned tribunal with respect to all the 4 villages. This witness has been duly cross-examined, and admittedly he was not there at the time of acquisition of the land. And his deposition certainly does not match with the records as discussed above, inasmuch as he has incorrectly stated that the compensation was paid to the claimant as per the existing market value, and now they were not entitled to get any more compensation. Although only 80% of the compensation amount appears to have been paid to them on the basis of the exhibit R2/B/3, read with the area of acquisition as recorded by the learned arbitrator and not in dispute during the course of arguments. So far as witness number 2 on behalf of the respondents before the learned arbitrator is concerned, he is SDO 3 in the Office of Defence State Officer, Job Circle, Nanagpur, Kent since November 2010. He has also deposed on similar lines and asserted that the land losers accepted the amount of award without any protest in the year 1970 itself, and there was no protest by them. So they are not entitled for any claim of more amount. And in paragraph 6, he has stated that after adopting due process under the Act of 1952, compensation of the land was paid to the land losers. And they were, in para 8, he has stated that they were paid as per the existing market rate and not entitled to get any more compensation. This witness was also not there at the relevant point of time, and for similar reasons, the evidence of this witness that the compensation was paid to the claimant at the relevant point of time and nothing more was payable is not correct. दो ही विटनेस है ना? थ्री तीसरा नंबर पे
रेस्पोंडेंट नंबर 2 डिस्ट्रिक्ट लैंड एक्विजिशन।
अच्छा, डिपोजिशन विटनेस नंबर 2 तो हो गया। उसका डिस्ट्रिक्ट लैंड एक्विजिशन ऑफिसर उनका एविडेंस नहीं दिख रहा है, ऐसे क्रॉस एग्जामिनेशन दिख रहा है, एविडेंस नहीं दिख रहा। Witness number 1, deposition witness number 2, ये अभिनंदन अंबष्टा, Abhinandan Ambashta, the district land acquisition officer, has been examined as witness number 3. He has stated that he was working as district land acquisition officer Ranchi since December 2012 and had submitted photocopies of the relevant records of all the 4 villages and will be able to answer any query or question by referring to the records only. With respect to issuance of Form J, he has stated that he could say so only by seeing the records. Form J तो exhibit नहीं हुआ। Upon a query to the learned counsel for the parties, admittedly Form J has not been exhibited before the court, before the learned arbitrator.
केवल इनके तरफ से अवार्ड और एक्सेप्टेड आया क्या?
This witness during his cross-examination has stated that compensation has been paid as per the prevailing market rate and has also stated that compensation has been adequately paid by the defence to the land users at the prevailing market rate existing in the year 1971, and at present there is no outstanding amount to any land users. The evidence of the witness number 3 on behalf of the respondent before the learned arbitrator also does not tally with the record. In view of the aforesaid discussions, which reveal that only 80% of the compensation amount was offered and paid to the concerned land users. At this stage, it would be useful to refer to the two judgments which has been relied upon by the Learned Council for the Union of India. In the judgment passed by the Honorable Supreme Court in the case of Union of India versus Munsha and others Supra, the facts reveal that under Section 8 of the Act of 1952, an award was prepared way back in 1970. And in 1986, a writ was filed seeking appointment of arbitrator. The learned arbitrator awarded the compensation amount and also awarded 30% solatium and 9% interest per annum for 1 year, and on expiry thereof at the rate of 15% on the enhanced compensation. The award was challenged in appeal, and the appeal was dismissed. During the pendency of the LPA against the order of the learned single judge, the High Court had directed by the impugned order dated 5/3/1993 to release the payment of compensation forthwith in view of the land acquired. And it was this order which was under challenge before the Honorable Supreme Court. It was a specific case of Union of India that on failure to accept the offer of payment of compensation determined by the competent authority, though the claimants had not communicated in writing their refusal to accept the award, it was argued by the claimants, though the claimants had not communicated in writing their refusal to accept the award on expiry of the prescribed period, a duty was still cast upon the competent authority of the central government to appoint an arbitrator. And therefore, the Union of India was enjoined to make good the losses by paying interest, and reliance was placed in the judgment passed by Honorable Supreme Court in the case of Union of India versus Hari Krishna Khosla, reported in 1993, supplementary to ACC 149. In the aforesaid background, the question posed by the Honorable Supreme Court was whether the Union of India was liable to pay interest to the claimants for the delay in appointment of arbitrator. The Honorable Supreme Court examined the provision of the Act and observed that under Section 8(1), the compensation is to be determined either, number one, fixation by agreement, Roman 2, determination by arbitrator to be appointed by central government, where no agreement can be reached. The Honorable Supreme Court also observed that Section 9 enjoins payment of amount of compensation under the award, and therefore the authority has to pay the amount of compensation to the persons entitled in such manner and within such time as may be specified by the award. And under Rule 9 with the bracket 3, the land acquisition officer is enjoined with the duty to communicate duty as soon as may be practicable to communicate to each interested person an offer which is fair in his opinion of the amount of compensation payable to such person in respect of the acquired property, and upon an offer being made to such person, he shall within 15 days of the receipt of the offer communicate in writing to the competent authority his acceptance or otherwise of the offer. And if he accepts the offer, the competent authority should enter into an agreement with him on behalf of the central government in Form K. In this background, the Honorable Supreme Court ultimately held in paragraph 5 that reading of Rule 9, the reading of the rules under the Act of 1952 indicate that after an award has been made, the competent authority is enjoined to communicate its offer in writing to the persons interested. And such interested person is also enjoined and shall communicate within 15 days of the receipt of the offer in writing to the competent authority his acceptance or otherwise of the offer. And if the offer is accepted, agreement in Form K is to be entered into. And if the interested person does not accept the offer, nor communicate within 15 days of the receipt of the offer in writing, the competent authority has to submit to the central government a report with full facts. And with full facts, in particular the nature and the extent of this agreement between the district land acquisition officer and the interested person. After having held as aforesaid, the Honorable Supreme Court distinguished the earlier judgment passed in the case of Sito Devi versus Union of India, which was relied upon by the claimant and found and recorded that it was found by the Honorable Supreme Court in the facts of that case that the claimants had accepted the amount sent to them under protest. And therefore they did not sign the agreement in Form K which was sent to them. And observe that in the case at hand before the Honorable Supreme Court, the claimants had not communicated their acceptance or otherwise of the offer made by the competent authority. And there was no duty cast on the Union of India to appoint an arbitrator. And therefore, the Honorable Supreme Court was of the view that the judgment passed in the case of Hare Krishna Krishna did not help the claimants, and observed that there was no question of payment of solution and interest, and found that there was no lapses in the appointment of arbitrator in the case at hand, as the obligation to appoint the arbitrator arises when the interested person communicates his non-acceptance to the offer enjoined by sub-rule 5 within bracket 1 of Rule 9. The court also observed that the requirement of sub-rule 6 to submit a report to the central government, where the person to whom offer has been made does not communicate within 15 days, cannot be regarded as required by the central government to appoint an arbitrator on knowing about the fact of non-communication of the interested person. The Honorable Supreme Court held that something more was needed to require appointment of arbitrator, that the interested person must communicate about his non-acceptance of the offer, which was not done in the case at hand. This court finds that the aforesaid judgment of the Honorable Supreme Court is clearly distinguishable on the facts of this case. The Union of India has completely failed to establish that full amount of compensation was ever offered to the claimants. Rather, the documents I discussed above reveal that what was offered and paid, showing the amount as amount payable in exhibit, are in the aforesaid exhibit as discussed above was only 80% of the amount. In such circumstances, and apart from that, no further evidence has been placed before the learned arbitrator, and no such evidence has been pointed out by the Learned Counsel for the Union of India with regard to offer of the full compensation amount. In such circumstances, this court is of the view that what was offered was only 80%, and therefore it cannot be said that there was any laches on the part of the claimant with respect to registering their protest upon offer of full compensation amount. Admittedly, in the present case, the report of the competent authority which was required to be submitted to the central government, to the Union of India, has not been exhibited. It is not clear as to whether the report was at all prepared or not. This court also finds that at the relevant point of time, the concerned district land acquisition officer was conscious of the fact, apparently was conscious of the fact that only 80% of the amount was paid to the claimant. And therefore, he had suo motu issued a notification dated 5/6/1993 for appointment of arbitrator. And it was this notification which ultimately revived, and the matter was referred to the present arbitrator. This court finds that the learned arbitrator in his award has also recorded, बताइए तो कहाँ लिखे हैं, that in absence of Form K, कहाँ पे इनका फाइंडिंग है, इशू नंबर 8 में भी है. In such circumstances, the learned arbitrator has rightly recorded by deciding issue number A and B that
Page number 13 of your work.
yes, that the claims were maintainable, and the arbitration proceeding is not only confined to 20 writ petitioners, but it would cover all the land users mentioned in the notification dated 5/6/1993. It is not in dispute that any agreement in Form K was never entered into between Union of India and the claimant, and there is nothing on record to show that the agreement in Form K was ever forwarded to the claimants. ऐसा कोई evidence नहीं है ना? So far as the other judgment which is reported in bracket 1996, bracket close 7 SCC 740 is concerned, in the said case, two sets of civil appeals were disposed of. In the first set, since the arbitrator was already appointed, it was kept appointed and the award was prepared and was challenged before the High Court, which was pending. The Honorable Supreme Court did not express their view. But so far as the other set of civil appeals are concerned, the Honorable Supreme Court was of the view that the case at hand was squarely covered by the judgment passed in the case of Union of India versus Munsha. The court recorded that since no action was taken by the claimants in communicating the objections for not accepting the award within the time prescribed under law, it must be deemed that they have accepted the award, and consequently the omission to appoint the arbitrator was not vitiated by any error of law. The said judgment also does not apply to the facts of the present case in view of the aforesaid findings recorded that the awarded amount in full was never offered to the claimant, and no material has been placed on record by the Union of India to show that the entire awarded amount was forwarded to the claimant, much less paid to the claimant. Rather, what reveals from the record is that only 80% of amount was offered and was paid.
You may also see page number 32 of the award, there is a specific finding with respect to form K, para 31 of the award. Page number 32, para 31.
Of the award, that finding is incorrect.
There is no agreement in form K.
That's
That
right.
is there.
That's
That specific portion was the finding.
I have also said that there is no agreement in form.
Yes.
And I have also said that you have not produced anything to show that it was forwarded.
The ladyship was asking where is the specific
Yes.
finding?
There is a finding of the learned arbitrator in para number
31, page
31.
number 32 of the award.
Page number
32 of the award.
of the award that there has been no agreement in form K. Para 31 of the award is quoted as a.
That is the specific finding.
That's it. Thank you, sir. It is audit. A lot of argument has been advanced by the learned counsel for the appellant by referring to the judgment passed by this court decided on 16/1/2008 within bracket Virendra Mehta versus Union of India, which was whereby this court had refused to appoint arbitrator. Refusal है ना सर? They had refused to interfere with the notification dated 18/11/1993, cancelling the earlier notification dated 5/6/1993 and restoring the notification dated 30/10/1993, and thereby confining the arbitration only in connection with 20 repetitions. And has referred to the findings recorded therein. The fact remains that the said judgment was set aside by the Honorable Supreme Court, inasmuch as the notification dated 5/6/1993 extending the arbitration to all the how many claimants?
753 land.
753 land users.
623 अवार्ड है, इसमें लोग इन्वॉल्व होंगे 50,000 से ऊपर।
हम नहीं जानते।
अभी
उसमें लिखा हुआ है ना?
Para 11 notes of the judgment, it says it is also noticed that though it is claimed that the petitioners numbering 20 represent all 753 land users.
ये सुप्रीम कोर्ट के जजमेंट में है।
This is the High Court's
High Court
पोलिटिकल
judgment
अवार्ड है, 623 अभी जो हुआ
I don't know, was extended to all the persons whose name was mentioned in the notification dated 5/6/1993. Safe enough?
Supreme Court does not specifically refer to the number.
That's right. But 5963 refers to all the list.
Yes, indeed.
Is there.
Indeed.
Is there in 569.
My lord, it is written in the Supreme Court order.
Yes.
That 5,593
Is appellate and others also in respect of those persons who have lost their land pursuant to the notification issued by the state court.
That's right. The order of the Honorable Supreme Court challenging the judgment passed by this court in CWJC number 2273 of 1994 has already been quoted above. Relevant portion has already been quoted above. In this background, this court is of the view that the findings or discussions which has been recorded in the judgment passed by the High Court dated 16/1/2008 in Virendra Mehto and others versus Union of India in CWJC number 2273 of 1994 cannot be relied upon by the appellant, by the Union of India to impress upon this court that the arbitration was required to be confined only to the persons, only with respect to the persons who were 20 in numbers in the writ petition. Accordingly, this court is of the considered view that the learned arbitrator has rightly held that the arbitration cannot remain confined to the 20 writ petitioners, but has to extend to the persons covered by notification dated 5th of June 1993. The aforesaid, as a sequel to the aforesaid findings, this court is also of the considered view that there was unexplained lattice on the part of Union of India in not offering the full compensation amount to the claimant, and thereafter maintain complete silence and further did not exhibit any of the documents through which the claimants received the amount containing their signature. And the claimants had specifically stated before the learned arbitrator, the witnesses of the claimant had deposed before the learned arbitrator that they had accepted the amount under protest, and the records reveal that what was offered to them was only 80% by showing it to be the amount payable, and the Union of India did not even offer them the entire amount. The report of the competent authority forwarding the entire facts as per the provisions of 1942 having not been exhibited before the court, before the learned arbitrator, reveals that no such action was taken. The district land acquisition officer who deposed before the learned arbitrator was apparently not present in the year 1970, and he stated nothing except that whatever was available in the record, he could only depose, he can only refer to those records. Neither before the learned arbitrator nor before this court any material has been pointed out by the learned counsel for the Union of India that the report was submitted to the central government or full compensation amount was offered to the claimants or any form in any communication in form K was made to the claimant to enter into any agreement with the compensation amount. In such circumstances, the claimants being poor tribal people in the state of Jharkhand ultimately had to approach the Honorable Supreme Court for the purposes of appointment of arbitrator. And the entire sequence of events in connection with the appointment of arbitrator has already been narrated above. And ultimately the arbitrator was appointed much thereafter. The fact remains that the district land acquisition office, that the competent authority initially issued the notification dated 5th of June 1993, covering large number of claimants, but ultimately suo moto they confined it to only 20 persons, and it was this notification confining it to 20 persons which was ultimately set aside by the Honorable Supreme Court in the year 2010. This court finds that there has been delay and that is on the part of Union of India in the matter of award of compensation, in the matter of appointment of arbitrator. The arbitrator, while considering the point of solatium and interest, has taken into consideration the judgments passed in the case of Union of India versus Hare Krishna Khosla and other 3 judgments ये कल हम लोग लिखाए हैं, and has found very proper in the facts of the case that the Union of India could not contain that the land users moved the court in 1991 after 20 years of acquisition. And in the facts of the case, the land users could not be penalized. And ultimately awarded 20% solatium with interest at the rate of 9% as per the award. And the facts of the case. In the facts of this case, the learned counsel for the claimant had also sought to argue that the solatium ought to have been 30% and not 20%. However, admittedly, the fact remains that the Act of 1952 does not provide for solatium and interest. And it appears that 80% of the compensation amount was already paid to the claimants who had gone to receive the amount. This court is of the view that the learned arbitrator has exercised sound discretion in limiting the solatium amount only to the extent of 20%. And interest to the extent of 9%. अब 4 बज गया, कर लिखें।
एक चीज लॉ से
देखिए मोटा मोटी तो जो आप लोग का पॉइंट सब हो गया, अब बाकी हम सोचेंगे कॉम्पिटिशन।
परमिशन होती है, ये जो लर्नेड आर्बिट्रेटर जो अवार्ड बनाए हैं उसमें इंटरेस्ट 76 से कैलकुलेट किया है, ये गलत है। ये को जिस दिन हुआ है उस दिन से होना चाहिए। और ये सारा एविडेंस आया हुआ है कि 71 72 में मेरा एक्विजिशन हुआ है।
देखिए नया पॉइंट मत बहस करिए, हम आपको बहस करने में रोके नहीं, हम दिखा रहे हैं आपके सामने। नया पॉइंट मत बहस करिए, फिर वो लोग भी लगेंगे बहस करने।
ये कानून
was argued, my lord, that from the time of acquisition,
I have already whatever I have said, right? अब इसको कल है थर्सडे, कल नहीं लिखेंगे, मंडे को कल ये सारा ना करेक्शन होके हमको सजा लेने दीजिए। देखिए ऊपर नीचे होगा, थोड़ा इम्प्रूवमेंट भी होगा, लेकिन आप लोग के सामने लिखा रहे मोटा मोटी जो लिखाए हैं, दैट विल फाइंडिंग्स तो सेम ही रहेगा, उसमें तो कोई डाउट नहीं है, ठीक है। लेकिन थोड़ा बहुत करेक्शंस तो होना ही है। एविडेंस में थोड़ा सा कभी कभी लगा ना कि 2 पन्ना पलट गया तो किसी दूसरे का एविडेंस रिकॉर्ड किया, ऐसा हमको लगा रिकॉर्डिंग में, तो हम लोग उसको सब चेक करेंगे। लेकिन मोटा मोटी जो एविडेंस दिखाए हैं वो यही है। As the court time is over, pose this case for further dictation on परसों Friday।
Friday 145
क्या चीज? फ्राइडे को कुछ और रखना है? वो रेफरेंस
145।
आप इतने लोगों को क्यों बुलाते हैं कोर्ट में? उन लोगों को यूट्यूब उन लोगों को जुड़वा दीजिए, बोल तो कुछ सकते नहीं है कोर्ट में, आप परेशान करते हैं। तो उन लोगों को बताइए ना, वहाँ पर चले जाने के लिए दालसा में, वहाँ से भी देख सकते हैं।
बहुत सारे लोग हैं जो मना करते हैं। एक बार चाह रहे थे तो उसको देखे क्या 3-4 हजार देखना चाह रहे थे।
जब हम जज बनते थे तो लेडी जज को देखने के लिए भी लोग आते थे।
फ्राइडे को आप देखेंगे।
मंडे को होगा। आप लोग का हाथी निकल गया है, अभी भी एक बाकी है क्वांटम।
क्वांटम पर मेन क्वांटम करेंगे।
क्वांटम पर बाकी तो आप लोग का कंटेस्टेड पॉइंट तो सब निकल गया।
सब डिसाइड हो
फर्स्ट हाफ हम इसी के लिए नहीं पाए, थोड़ा सा देखना, कैलकुलेशन सब कुछ जरूरी है। चलिए अब ऑर्डर्स है ना,
From supplementary list for orders item 400, 2nd April 74 of 2017.
who is appearing in this case? Who is appearing in this case? आइए नंबर 15414 और 2025, ये पेंडिंग है ना, पेंडिंग। This petition has been filed for substituted service of notice upon the plaintiff slash respondent slash pro forma respondent. Stating that the appellant could not serve the notice to the said respondent. Considering the integrity application, the prayer for substituted service of notice upon respondent to is allowed. The notice be published in newspapers, Prabhat Khabar, and Dainik Jharkhand, having circulation in Jilla, Jharkhand. The counsel for the appellant shall furnish the format for service of notice, for substituted service of notice to the office, the office is directed to verify the same and give it to the learned arbitrator. पहला वाला within 2 weeks and thereafter a week thereafter. The supplementary affidavit annexing the newspaper be filed before this court. Go दीजिए. Date बता. Be filed before this court by 9th of January. Post on 9th of February. Are you post? Let a soft copy of this order be forwarded to the council.
Item 481, second appeal 446 of 2017.
What is this?
High order that is 6/11/2025. Notices have been issued. Notices have been served to respondent number 1 to 5, 6, B to C, and 9. And as per the office report, matter the respondent number 2, 6A and respondent number 8 died. And for that, matter I have to pay for 3 weeks time for taking his step for substitution.
2,
2, 6A and respondent number 8.
respond number?
8.
Council for the appeal submits that respond number 2, 6A and 8 have been reported dead. Seeks adjournment. We submit that respondent number 1, 3, 4, 5,
6B,
6B,
6C,
6C,
7 and 9.
7 and
9.
9. Seven and 9 has been received by themselves or through close family member. He submits that the notice be accepted as valid receipt. Considering the submissions, the notice upon the apposite respondents is accepted as valid receipt. कितना दिन चाहिए आपको?
3 weeks for taking his step.
3 weeks. कोई appear हुए हैं respondent की तरफ से?
Appear property status report not showing the appearance of income.
Just a moment. 3 weeks का पूरा हो रहा है इनका? Post on 17th of December.
From tail list for the repeat item 2, second appeal 334 of 2018.
Yes, ma'am.
There are 3 items in this matter. Firstly, I would like to draw the Asia's attention to IN number 14936 of 2025. which has been filed in November examination, 6th November 2023. This is an IA for amendment to the IA that we had filed earlier.
What is the error?
Your Ladyship, earlier we had filed a substitution petition being IA number 13026. In that, one of the substituted legal heirs name we could not add. So now we are adding that name and therefore we have filed this IA for amendment. 13026 is the original IA.
That is for condonation of delay.
For setting aside the abatement and substitution of the legal heir.
But your heading says for condonation of delay.
You just simply
Paragraph page 1. What have you done? Just a cover page. In the matter of an application under section 5 of the regulation. First page. Have you seen? My record is showing this only. This is what has been filed. But in the second page, you have mentioned that humble interlocutory application for condonation of delay in filing substitution application. Which is substitution?
should I verify the records once?
In the prayer, you have said that setting aside. Anyways, whom have you left out?
Arjun, I have mentioned in para 4, page 4, last portion. Respondent number 12.
Okay.
का substituted heirs.
देखिए, IA number 14936 of 25 with IA number 13. This interlocutory application has been filed for amendment of IA number 13026. The Learned Council has submitted that IA number 13026 has been filed for substitution of respondent number 1, 5 and 12, but due to mistake, one of the son of respondent number 12 has been left out, and accordingly an amendment has been prayed for through the present interlocutory application. It submits that the name has been mentioned in paragraph number 4 of the interlocutory application.
And what I want to amend is mentioned in para 5.
She seeks to amend paragraph 5 of the
Para 6 of the IA.
para 6 of the IA number 13026.
And proposed amendment to that.
Paragraph 6. This is in connection with respondent number 12.
Yes,
Where have you mentioned the details of the legal heirs? Respondent number 12. Which para? IA number 13026.
Para 6 may be seen at para page 6 that it is humbly stated and submitted that the respondent.
No, it is not matching. Para 6 of IA number 13026. Para 6, it is stated that once the appellant is a poor and illiterate lady and could not inform the council about the death of the legal heirs of respondent number 1, 5 and 12. यार क्या फाइल कर देते हैं भाई?
IA numbers are mentioned wrong in my file. Therefore, we have filed wrong IA. The section 5 application has been mentioned at 13026 in your ladyship's file. In my file, it is 13027. And 130.
ना कोई रेकलेस हो सकता है, लिखा है तो उसमें भी दिखता होगा condonation of delay. लिस्ट में भी दिखता है condonation of delay. दिखता है ना,
जिसमें तो 13026
सब्स्टिट्यूशन दिख रहा है, जबकि 13027 है सब्स्टिट्यूशन। और इसमें कॉस्ट एस्टिमेट से लिखे हैं ओनली सब्स्टिट्यूशन ऑफ रिस्पॉन्ड नंबर 5 इन 13027। लिखिए भाई, फिर से लिखिए। During the course of arguments, it appears that there is complete mismatch in IA number 13027, 13026 and 14936. टू 2018 का है। अच्छा, एक साल अटेंड कर लेते हैं।
Parties went for mediation, your ladyship. Mediation has been concluded. There is mediation report in favor, your ladyship, that the mediation has been successful. The only reason we had filed this was because the parties were not substituted, your ladyship. Ultimately, the suit could not be decided. I'll not
The
press
counsel
all
for
the
the
IAs, your ladyship.
You will not press without substitution कैसे होगा?
But your ladyship, I'll file fresh IA within 2 weeks, your ladyship.
The learned counsel for the appellant seeks permission to withdraw all the interlocutory application and she with the liberty to file a fresh one. ठीक से बनाइए।
किसी को बताना होगा रेस्पोंडेंट्स पर
Notices were issued upon the proposed legal airs, your ladyship.
आप किसकी तरफ से आगे हो?
all respondents and substitute legal yes
Substitution was allowed. Not yet.
But notice was issued.
इनको मिल गया है ना, तो आप कब आइए फाइल करेंगे? कहाँ का मैटर है बताइए?
देवघर।
तो बुलाइए, आप आइए फाइल करिए, हम छुट्टी के पहले ही रख देते हैं।
Yes, your ladyship. Any date.
ठीक है।
After 10th.
Post on 16th in the supplementary process. सबका देख लीजिएगा, नाम टैली कर लीजिएगा। नाम नहीं टैली करेगा तो वकालतनामा डिफेक्टिव हो जाएगा।
ये भी तो
आइए, हाँ आइए, dismiss as not pressed with the aforesaid liberty. You put your signature on this.
Item 3, first appeal 1 of 2024.
Yes, appellant.
Pursuant to SR dated 1/10/2024, your ladyship, 2 defects are still remaining, your ladyship, pertaining to CC of the award, your ladyship, and one award signed by date mentioned in the agreed portion, your ladyship. Praying for 4 weeks time, your ladyship, to obtain the CC of award, your ladyship. 4 weeks, your ladyship.
It was dismissed.
Yes, your ladyship. COT file was restored.
AP number 1 of 24. The learned counsel for the appellant prays for and is granted time till 9th of January to remove the surviving defects. Granted. इसको 19 तक हो जाएगा?
19th of January.
नहीं, 19 of December.
Your ladyship, CC award obtained the national hard copy of award obtained the trial.
9th of January कर Entry है, the defects are removed within time, post on 19th of January.
Much ado.
Orders item 4, first appeal 5 of 2017.
Your ladyship, this first appeal was firstly admitted on 15/12/2018 and LCR was called for, but it was dismissed for default. But in the process for between the restoration, LCR was sent back to the lower court. So after the restoration, it has came and for the LCR was called.
office is directed to call for the records from the concerned court. Let this order be communicated to pass. Service is complete. Other side, appear. Who is appearing? किनका पता लगता है?
State Bank.
State.
Bank. Mr. Rajesh Kumar.
उनका सर्विस रिपोर्ट है कि नहीं है?
इसमें मिस्टर राजेश कुमार आ गया
है?
Date.
हाँ, डेट 22nd December.
Item 5, first appeal 188 of 2019.
There's a delay of 125 days in between first appeal. When I had
FA number 188 of 2019 with IA number 8958 of 2019. The interlocutory application has been filed seeking confirmation of delay of 125 days. The matter arises out of partition suit. Issue notice in the interlocutory application as well as in the main appeal. The records we also call for from the concerned court through the concerned police station. Notice कर दीजिए record मंगा लेते हैं. First appeal में delay कंडोन हो ही जाता है इसीलिए दोनों में notice है. कहाँ का मैटर?
Junction.
चलिए. Requisites within a week हो जाएगा? Let this order be communicated. Date 22nd. नहीं हो पाएगा इतना जल्दी. 8th of January.
Item 6 and 7 reading are only hearing.
So okay. Item number 6 and 7. The matter is reported to have been wrongly listed under the heading for orders.
But my IA is still pending.
Which I?
IA for continuing delay.
That is why it has been listed. You are for the.
I'm for the cross subject, respondent cross subject.
CO.
CO IA.
कौन है other side? Other side कौन?
Sir.
आप appear हो चुके हैं आगे में? CO में appear हो गए? There is no defect in CO.
Defect was for limitation.
Limitation में क्या बोलना है? How many days?
183.
This is first appeal.
Second, cross connection second.
Yes, what do you say? बताइए.
limitation for
IA number 9323. SCO number 11 of 25. This petition has been filed for condonation of delay of 188 days. The learned counsel for the appellant has submitted that the cross objector has submitted that the impugned judgment is dated 7/2/2020 and was admitted on 2/9/24. And the cross objection has been filed on 9/2/25. He has referred to the interrogatory application, showing the reason for condonation of delay. The learned counsel for the opposite party, they will be called opposite party. Number?
1.
1. What about others?
I've taken steps for notice on them.
Sir?
So far as opposite party date is concerned,
8 is concerned, Vakalatnama I think has been filed day before yesterday. And my friend is representing respondent number 6, state of Jharkhand is also appearing. Mr. Akshanov is perhaps representing opposite party number 1.
ऐसे कि ना notice complete नहीं, notice is not complete. You should have pointed out unnecessary.
I did not know. But contesting is only opposite party number 1.
Contesting is only
Opposite party.
Are you sure?
Because his second appeal has only been preferred by opposite party.
The contesting respondent has opposite party number 1 has no objection so far as the prayer for condonation of delay is concerned. Considering the submissions, and being satisfied with the cause shown, the IA number 9323 seeking condonation of delay is hereby allowed. Respondent number 2 comment.
They were defendants, but they did not prefer the appeal. Second appeal is only by the opposite party number 1.
आज के ऑर्डर में नहीं करेंगे, that some of them has not been served. Next week.
Sure.
Post on next Thursday. आइए लो.
Item 8, second appeal 190 of 1020.
And it's the office report reveals that notice respondent number 5, 8 and 15 they have died. For that matters, for this type of file. And
5, 8 and 15 have died.
And respondent
5, 8, 15.
5, 8 and 15 have died. Respondent number 3, she resides at another place in Madhupur. And so for 22 is stated that address of the notice falls within the district of West Bardhaman. And 6 to 18 and 23, SR has not been rest of the notices that have been received by self or by
Respondent number 5, 8 and 15 have been reported dead. As back as on 25/3/25. एटीन 3/25 को भी यही है. The proceeding has apparently abated in connection with the aforesaid respondents. The counsel for the appellant pays for time. अब बताइए आपको कब चाहिए? Abatement तो already हो चुका है. It takes automatic command. No order of the court is required. अब कब चाहिए? Time is running against you. When do you want? बताइए कहाँ के आप रहने वाले हैं तो इतना आपको सोचने में टाइम लग रहा है. कहाँ के रहने वाले हैं? कब रखना बताइए? At the request of the counsel for the appellant, post this case on 16 December. हो गया? 3 हफ्ता कंप्लीट नहीं हुआ? 3 हफ्ता हो गया कि नहीं हुआ?
Item 9, CO 20 of 1021.
Who is for the appellant?
It is an admitted cross appeal arising out of a first appeal number 37 of 2020. And that first appeal was not dismissed for default, against which they preferred an application for restoration, that is CMP 554 of 2024.
CMP 554 of
2024.
क्या कि वो भी डीएफडी हो गया, सीएमपी भी डीएफडी हो गया, तो स्टेटस बताइए।
No objection has been taken by defense. So my name is again that.
नो ऑब्जेक्शन इसमें
फर्स्ट अपील दोनों में लेके गए हैं, इसमें उसमें तो सीएमपी फाइल
डीएफडी कराइएगा तो नो ऑब्जेक्शन तो लेके जाएगा ही बंदा, क्या करेगा।
तो फर्स्ट अपील में दे हैव फाइल द सीएमपी पर इन द सेकंड इज
इसका जरा स्टेटस बताइए, सीएमपी 554 डॉक्यूमेंट। कॉन्फिडेंस शेक हो जाता है जब केस डीएफडी हो जाता है, करेक्ट।
समटाइम
इससे अच्छा है कि मेरिट पे डिस्कस हो जाए।
आउट ऑफ लिस्ट
किसके बोर्ड का है, कहाँ का ऑर्डर है?
इट मे बी
कोड नंबर 9
कोड नंबर 9।
अब इसमें क्या करना है?
वेट कर, बस सीएमपी होगा तभी इस पर कुछ कार्रवाई होगी। सीएमपी डिसमिस हो जाएगा ऑटोमेटिक, इसका फिर ये नहीं।
इसका तो इंडिपेंडेंट हियरिंग होगा ना।
हाँ, इंडिपेंडेंट राइट है। एडमिटेड केस है 28th of September 2022 it was admitted.
लिखिए CO number 20 of 2021. It has been submitted that the connected first appeal has been dismissed for default, and an application for restoration being CMP number 554 of 24 is pending. Office is directed to place this case after disposal of CMP number 554 of 2024 or on 26th of February, whichever is earlier. हो गया बस। कल हमारा क्या फर्स्ट हाफ के लिए क्या फर्स्ट हाफ उसमें कल मंडे कर दिया, उन लोगों को बुला के कैलकुलेट कर दीजिए। कल हम छुट्टी इसीलिए बोल देंगे ना, हाँ 2:15 बजे, वो हमको याद नहीं, अभी उनको कम्युनिकेट कर दीजिए, है ना। तो कल हम छुट्टी इसी के लिए कि हमको फर्स्ट अपील इसको निपटाना है, ठीक है। हाँ टुमारो एट PM, हाँ सबको बता देंगे, वो जो ऑनलाइन ज्वाइन किए थे उनको
कंटिन्यू चला था,
हमको याद है, हम लोग थे।
फर्स्ट अपील का जो बैच देखे उसमें तो समय लगा, इसमें मुझे बहुत कम समय।
नहीं वो तो दूसरा बहुत ही कॉम्प्लिकेटेड था। आई रिमेम्बर हम सुनते थे उसको बैठ के, क्योंकि काम तो कुछ था ही नहीं मेरे पास, तो आराम से बैठ के सुनते थे, पूरा दिन सुनते थे हम उसके। दिगंबर जैन एंड स्वयंबर जैन का कहानी, एंड एक से एक एडवोकेट्स आते थे। आई डोंट रिमेम्बर, नाम नहीं याद है, बहुत फेमस एडवोकेट्स सब आते थे।
बहुत दिन चला
था। ये होगा आई थिंक 96 नहीं, हम 94-95 में तो ज्वाइन ही नहीं किए।
नहीं सॉरी
98 कोर्ट नंबर 2। दिस इज देयर वाज ग्रेट, सिविल उनका बहुत जबरदस्त। चलिए